All right. Welcome, everybody. I hope everybody who's online can hear us. We do have an opportunity to ask questions. If you don't hear something, if you're online, please let us know. We want to make sure that you are joining us from wherever you are. And we are based, well, right now we're finding ourselves over Bryant Park at the fine offices of Steptoe. Thank you very much for hosting us. All right. I'm not seeing any comments online, so you guys can hear it, right? Great. Ready? My name is Irina Tarsis. I am very fortunate to be working at the Center for Art Law together with my colleagues at Mathor, and a number of our team members are in the room, so I hope you'll have a chance to talk to our fellows and volunteers and interns. Today's program is a very interesting experiment for us. This week, the center is running its first summer school. We've been learning about primary market issues, secondary market issues, copyright law, what makes art markets tick. And after visiting Brooklyn Museum in the morning, we think the next proper stop about the ticking of the art market is to talk about financial crimes, because they are a side effect of what may happen when a lot of art comes anywhere, New York or London. I think many of you have attended some of the fairs that took place earlier this week. Many of you are watching what's going on at the important auction sales that are happening this week. And it's time to talk about regulations that concern the art market. The program that we are hosting here is called Making Sense of the Anti-Money Laundering Regulations and the Art Market. There are handouts that were sent to you. There's an incomplete but a sizable list of various abbreviations that come with this territory: AML, CDF, OFAC, et cetera, If you have questions at some point, you can ask either by asking, you can ask online, you can look at the handouts, you can make a note, you can Google it, but it is an alphabet soup, which we will try to not dilute, but explain and make sense of. All right, so with that in mind, working? Yeah, we should click it and then hopefully all right, for those of you who haven't heard about the Center for Art Law, we're a huge institution, nonprofit based in Brooklyn with a huge outpost in Zurich, Switzerland. We definitely have a huge ego, and we have a big footprint. The students who are joining us for the summer school, they come from all around the world, actually. And we're very pleased to have you here, and we hope you're learning a lot, and you'll be able to spot money laundering and prevent it. First time it ever happened. If there's more you want to know about the center, we have a very robust website. We publish articles. There's going to be a new annual report coming out in a couple of months, and you'll all be included in it. We also host conferences such as the Nazi Eluded Art Conference that we had last month, and most of our events are archived. All right, Zach, where's your picture? It's there, I swear. It was there this morning. All right.
Just have to look at that. Yeah, it's much better. Every fine work of art is much better.
Morning. So we have, originally we thought we would only have Andrew Adams and Sam Kleiner speak, but we're very lucky because Zach Goldman is also joining us, and the three speakers have done quite a lot of work on preventing money laundering, on understanding it, and also educating art market participants as to what they should do to prevent it and what they shouldn't do to advance it. All right, so these are our speakers. As in the bios of everybody, every bio is in the handouts as well as the reading materials. Please take a look.
Crazy.
Know about money laundering. There are certain good practices, theoretically, that art market participants ought to engage in. They should conduct due diligence, even if they don't know what it is. What are they risking? They're risking embarrassment. It's not a small thing when you bring something to a fair and law enforcement shows up and takes it from you. This is an example of law enforcement focusing on Asia Week a few years ago and taking a few of the objects that were improperly imported and definitely properly looted out of their countries of origin. All right. Art fairs that we have discussed and auction houses that we have visited and will discuss and will visit, they are aware of possible improprieties. And so they also try very carefully to encourage their visitors, participants, clients to conduct due diligence. This is an example of an art market principles and best practices from one of the leading art fairs, Art Basel. They don't have to do this, but they think they should, and they do. They have published an expectation of best practices guidelines. And they ask exhibitors who pay good money to have the white cube to bring art to conduct appropriate due diligence. There's no definition in establishing the origin, authenticity of the work, which they offer for sale or display. And what they should try to avoid as best they can is bringing stolen, looted, illegally exported, inauthentic objects, and try to avoid introducing products of other crime activities. We're talking about the other crime activities here. TAFAF, for those of you who've been with us all week, we went to TAFAF New York. TAFAF also has their rules of conduct, and they ask kindly their dealers not to bring illicit materials and not to engage in criminal activities. It's on them to abide by these suggestions and principles. Otherwise, they might make the news. Otherwise, they might become subject of investigations and find themselves in very uncomfortable positions. All right. This painting we haven't seen in person, but we have heard about this work of art. And what you should take away from Salvador Mundi, big money is operating, circulating in the art market. It's good to know where it's coming from. It's good to know where art is coming from, and you should conduct whoever you are, wherever you are in this field, knowing your client is the way to avoid facilitating criminal activities. All right, there's a list of various regulations, a bit arbitrary because it can go any which way. We can look at New York, we can look at the United States, we can look outside of the United States. What we invite you to think about is Bank Secrecy Act, and what does Bank Secrecy Act have to do with the art market? Dealers are not banks, are there? Or are there? Certain financial action suggestions, here's a second, I guess, acronym, FATF, Financial Action Task Force. In 2012, that's more than a decade ago, issued recommendation about fears of money laundering, offenses related to money laundering. Fast forward to today, welcome to May 15, 2025. In the UK, it's now mandatory for British or UK-based dealers to report if there are suspicious activities involving art market transactions. So things are happening as we speak, and what are they and how do we understand them to avoid being criminally liable, out a few thousands or millions of dollars and many hours out of luck. The last thing I want to say is I feel particularly strongly about this subject in connection with a lot of sanctions and a lot of activities that certain collectors have incidentally facilitated. There is a big chunk of what we're discussing concerning oligarchs who are involved with collecting art and facilitating the war that is happening in Ukraine. Today is not only the day when UK is asking high value dealers to start reporting on suspicious activities. Today is also a day when people wear national dress, Ukrainian vyshyvanka. This is the reason I'm dressed up for it. And who knows, some of these crimes we're talking about might be heard in the newly created special tribunal we're talking about. I'm not sure it's been created, but I think it's coming. And some of the crimes we're talking about, like money laundering, may or may not make their way into that. So with that in mind, knowing that you have full bios of our speakers, we're gonna take a few steps back, a few years back, and talk about what are the regulations that are money laundering related and art market related. And Sam Kleiner is gonna start us on this subject.
Well, it's a real privilege to be here, and thank you for the invitation to join you, and great to be with Zach and Andrew. I'm also particularly honored. My sister, Emma Blumenthal, is a longtime art lawyer who's worked with the Center for Art Law before, and I'm a sanctions and AML lawyer, which is not nearly as cool. So this is like very exciting for me. My relationship with my sister, who's joining us by Zoom, to be able to join you today. So, and recognizing that a lot of folks are new to the world of AML and sanctions, I think it's just helpful, as we were discussing, to break down what some of the separate regulatory concepts are here. And so I actually was going to start with sanctions. And so sanctions are a regulatory framework that is pursuant to a statute called IEPA, the International Emergency Economic Powers Act. And you'll hear a lot about sanctions if you look in the news, basically every day. You'll see sanctions that are implemented on certain countries. The president just announced the removal of sanctions on Syria this week and on certain persons. And so a lot of, you might be familiar with designations of certain Russian oligarchs that's maintained through a list called the SDN, or the Specially Designated Nationals list. And it is a crime for US persons or persons subject to US jurisdiction to engage in transactions with SDNs or in violation of sanctions laws. There's an interesting and longstanding exception to the sanctions regime that has to do with art. There was a congressman named Howard Berman who introduced an amendment to IEPA called the Berman Amendment, which was intended to exempt essentially the free flow of ideas. So it exempted informational materials, so books, and it exempted artwork as a category that's subject to sanctions. And this has remained an area where there's case law that talks about what this means. But there was a really important announcement from the Treasury Department. Has an office that administers sanctions called the Office of Foreign Assets Control, OFAC. And in 2020, OFAC came out with really significant guidance on this, where they said, we understand this law, the Berman Amendment says that art is not subject to sanctions, but they said in this guidance that for high value artwork, which they define as artwork with an estimated market value of more than $100,000, they essentially said the sanctions do apply. And they said that because they consider it as essentially as a store of value, that artwork at $100,000 or more has a significant, can be used, and they talk about a number of different case studies of how artwork at that type of value can be used as a way for terrorist groups. So they talk about Hezbollah and how Hezbollah has utilized the art market as a way to raise funds, and essentially said there's a significant amount of national security concern with these types of transactions, such that there is the application of the OFAC sanctions on these types of transactions. And what does that mean? So if art is not categorically exempt from the sanctions regime, it means that persons engaged in the art market need to be mindful of the sanctions risk. So we'll talk about the Bank Secrecy Act and money laundering, which applies to certain types of institutions, but the OFAC regulations, the sanctions regulations, apply to everyone. So it applies to all of us individually, it applies to all US companies, it applies to banks. And what OFAC is saying in 2020 is that does apply to participants in the art market. And so the guidance says that OFAC strongly cautions that any US person considering a transaction with a blocked person involving high value artwork should seek guidance or license from OFAC. So OFAC is a whole process where you can get a license if you are engaging in an otherwise prohibited transaction. But the bottom line from that, though, is how do you know if the person that you're engaging in a transaction with is a blocked person, is on this SDN list, or is otherwise subject to sanctions? That goes back to the point that you have to be able to do appropriate due diligence on who the buyer is, and where that may not be transparent from the face of the transaction, it requires an assessment of who the beneficial owner is. So OFAC has what they call the 50% rule, that an entity that is owned 50% or more by a specially designated national is also considered to be a blocked person. So if you have, an LLC that comes in and says, we want to buy this piece of art at $100,000 or more, essentially what OFAC is saying is that you need to be able to understand who the buyer is for that piece of art. So this was a pretty significant piece of guidance when it came out in 2020. I think, there's a lot of interesting dimensions to this we can talk about also in terms of NFTs and the digital art market. I'll try and keep the rest of this brief. I think, the other part of this, of the regulatory framework is the AML landscape. And the main law that we talked about is the Bank Secrecy Act. The Bank Secrecy Act applies to certain types of entities that are subject to specific obligations that are promulgated under regulations. That includes financial institutions, not just banks, but all types of different financial institutions. And in a recent amendment, the antiquities market was added to that. Art is not formally subject to the BSA. And we can talk more about discussion about that. And there was this 2022 Treasury report that we discussed that talked about the money laundering risks. But I think generally we would say that, for reputational reasons and a number of prudential reasons, the lack of sort of a formal money laundering imposition on art institutions doesn't mean that it's not a concern, that it's still really important to do that diligence. And particularly where, most of these transactions are going to go through a bank, you can expect also that banks, generally are going to expect that type of diligence is done. And you may have obligations in your relationships with financial institutions to do that type of diligence. And obviously, and we can talk more about the Treasury study. The Treasury study says, there's a lot of aspects of the art market that make it particularly attractive for money laundering, including the fact that art is a way to store value, and that it's, it can be transported, in a much easier way than you look at something like, there's a lot of discussion, particularly in New York and other cities, about money laundering associated with the art market. You can certainly launder money through a penthouse apartment, but it's a lot harder to move a penthouse apartment across borders. So there is something that is very attractive to money launderers to look at the art market as a way to try and move cash, which ultimately, when you think about, at a high level, money laundering is about, having illicit funds, and you're trying to move them into the legitimate market, and art can be a way to do that. So I'll stop there because there's a lot to talk about.
If you have questions, please jot them down. One question for you before we move on. So this report that you mentioned, it came out in February of 2022, right? And can you talk about how much work went into writing it? What were the expectations from it? I don't know if they were met, not met.
Yeah, and so I was at the Treasury Department when we worked on this report. I came in sort of at the end of the process. There was a team at Treasury that spent a long time working on the report, and I think it made, it obviously had a significant impact in really, I think, showcasing a lot of typologies, and it's worth reading that. And I think, generally, as you think about trying to build a compliance program, it's important to be reading of these sorts of reports that come out, because they, the government isn't really not trying to hide the ball when they're talking about, what they think the risks are. But I do think it's important to note, one of the questions that was one of the central purposes of the report was whether certain art market participants could be subject to the AML regulations of the BSA, which would take a statutory change. And the report ended, this is very government language. It says Treasury should accordingly consider the costs and benefits of applying AML/CFT, countering the finance of terrorism requirements to potentially include customer identification and SAR obligations to certain art market participants, and consider which government authority should be charged with supervising those market participants. Essentially saying people should keep looking into this. And so I think the recommendation from the government was ultimately, a little ambiguous as to whether, that the statute should change to apply AML regulations here, and we'll hear from Zach about sort of the latest thinking on Capitol Hill, but we have not seen a lot of movement, I think, in that direction towards actually applying formal AML regulations in this space over the past couple of years.
As you mentioned, the report seems to have enough arguments for both sides, because when you go to a conference, somebody can say, well, the Treasury said we don't need to regulate it officially. And others say, well, the Treasury said there are plenty of instances for malfeasance, and so we should be aware. But the report is used both by those asking for more regulations and those who are advocating for less regulations.
Yeah, and I think, look, I think the regulations are what they are. They haven't changed, and the report doesn't create new regulatory obligations. But I think we've seen, particularly in the past couple of years, a significant amount of enforcement activity. And Andrew can talk more to this about, particularly, under the prior administration, a lot of focus on Russian oligarchs and dealings in the art market. We continue to see a lot of focus on, particularly with Hezbollah and the way that art is used as a way of funding terrorist activity. And I think, in the new administration, we just saw the Department of Justice come out with some pretty significant guidance about what they see the priorities are. And I think we'll see, the degree to which the art market has links to those priorities. You might see increased enforcement activity and scrutiny.
I think one way to square those two perspectives, Irina, is to think about the question of whether the government should regulate something is different from the question of whether there is risk involved in a particular transaction, right? Those are quite different. And maybe it's a way to sort of pivot. I can sort of elaborate a little bit on Sam's really fantastic introduction on the sort of evolution of the thinking around money laundering regulation with respect to the art world. Because I think that gets at precisely the question you asked, which is people kind of use that report as a sword and a shield, right? So as Sam said, the Bank Secrecy Act is the principal statute that imposes anti-money laundering regulations on, quote, financial institutions. And that's a defined term in the statute. There's something like 27 or 28 different subcomponents of the definition. And they include what you think they would include, like banks and broker-dealers. They also include fun things like pawn shops, boat dealers, telegraph operators, things that haven't seen the light of day in quite some time, right? And the act was adopted in 1970 in response to concerns about things like tax evasion. It was substantially strengthened in the 80s and 90s in response to the international drug trafficking, the expansion of international drug trafficking and money laundering that was associated with international drug trafficking. It was dramatically strengthened and expanded right after 9/11 with the Patriot Act. And it was again strengthened and expanded about 5 years ago with the adoption of the AML Act of 2020. And that's the statute, Sam said, that mandated the regulation of antiquities dealers under the BSA. And so it added this category number 27, 28, whatever it is, and then mandated the study that ultimately came out in 2022 with respect to art dealers. I think it's useful, and Sam, I think, did a great job introducing this, to think about what is money laundering. So money laundering traditionally is thought of as having three elements, but broadly means taking something that is the proceeds of some kind of criminal activity and engaging in a bunch of financial magic to make it appear to the outside world as legitimate proceeds of lawful activity, right? So taking the proceeds of drug trafficking, for example, washing it through a bunch of legal entities, mingling the cash with all cash businesses, et cetera, et cetera, et cetera, and then using those proceeds to buy a house or a car or something that seems legitimate, and then turning around and selling that house or car, and then all of a sudden you have eliminated or attempted to obfuscate the source of those funds in illegal activity. And the concern is quite obvious. As Sam said, art is mobile, it can be valuable, it's a global market, so you can buy a piece in one jurisdiction and turn around and sell it in a different jurisdiction. And so it has some of the characteristics that people think of as potentially posing money laundering risk. And so for years, sort of on and off on Capitol Hill, there had been debates about how great a risk is this? How big of a deal is this? Should we amend the Bank Secrecy Act to cover dealers in art or antiquities or some version of this? And so ultimately in 2020, 2021, Congress came down and said, okay, let's study the problem and see what we can figure out about whether this is something that commands regulatory or should command regulatory attention. And I think the ultimate conclusion of the study, as Sam said, was not that there's no problem here, nothing to see here. It's, yeah, there are episodes that have been identified where money is laundered through art transactions, where, you know, terrorist groups, there was one Lebanese art dealer who was sanctioned and then indicted for providing material support to Hezbollah. There were reports that the Senate Permanent Subcommittee on Investigations in July of 2020 published a big report on these Russian bad dudes, the Rotenbergs, who were very close to Vladimir Putin, who moved assets in contravention of the sanctions obligations through art purchases where their interest in those art purchases had been obfuscated. So but the fundamental question was, okay, so, and therefore, right, should the government expend its resources in developing a regulatory scheme to supervise this activity? And I think the conclusion was in part based on the concept that the art market itself is actually relatively small scale. So the global art market, many of you I'm sure are very familiar with the UBS Art Basel Global State of the Art Market Report, right, just came out a couple of weeks ago for 2024. The global art market in 2024 was $57 billion. The US art market was like $25 billion. There are hedge funds, many of them probably in this building, that are much larger than that, right? And I think part of the conclusion was there are episodes of really bad stuff happening to the art world, but there are also characteristics of art transactions that make it challenging to launder money at scale. So yes, the $70 million Giacometti sculpture gets a lot of headlines, but the vast majority of transactions are much, much smaller, right? And so it's hard to move a lot of money buying $1,000 or $1,500 prints. It's hard to clean a lot of dirty money buying $1,500 prints. And at the same time, the Treasury Department, I think this context is super important, was considering a set of rules to regulate those gigantic hedge funds that are in this building and within a half a mile here, right? And ultimately did publish regulations governing the investment advisor space, which is like a $3 trillion market, and certain aspects of the real estate market, which is also gargantuan, right? And so I think the judgment that was reflected there was the regulatory energy of the US government is better focused on other things, at least for now. And it wasn't a blanket conclusion that there's no risk here. And so I think it is nonetheless the case, as Irina pointed out at the outset, that it is very important and very prudent for dealers to take sort of reasonable risk-based measures to control sanctions risk, money laundering risk, and other kinds of risk, right? You know, it is totally routine for dealers to have reps and warranties in agreements about the authenticity of work, right? Well, you know, it's also important to consider the kinds of reps and warranties you want to have in agreements that cover issues like sanctions and money laundering and things like that. And for people to have in mind, and we can talk about them, and I'm sure among the three of us, and I'm sure among this table, we could think of lots of red flags that folks should be on the lookout for. But I think that's the way to sort of square these perspectives, that just because the US government concludes its regulatory energy and regulatory priorities should be focused on something else at the moment, doesn't mean that there isn't risk that folks need to be sort of cognizant of and need to think about how to incorporate in their commercial practices.
And if I just to jump in on this very quickly for the next piece, I think there are three sort of thoughts that seem to me to motivate this as well. I agree with everything that Zach and Sam just laid out, but one is a definitional problem. I think Congress and Treasury have thought hard and had a hard time thinking about what is the art market? How do we define the actors that are going to be covered by this? When they expanded to antiquities dealers, there was a lot of confusion. They intend to conceal the proceeds of specific kinds of crimes. Not every crime is covered. And as it turns out, and in the sanctions situation, we see a lot of this, much of the, call it shady activity that's happening in the market is actually an attempt to evade the criminal laws of other countries and not the United States. It is capital flight, it is moving property that shouldn't be taken outside of Russia, for example, and parking it outside of Russia in a way that actually violates Russian law. That may have the feel of money laundering, but as a technical matter in the United States, it's not money laundering. And then the last point, I think, this may get into the next section. Notwithstanding the difficulties in drawing regulations, there are background criminal laws that motivate every actor in this space, that need to motivate every actor in the space, because notwithstanding the lack of a specific money laundering regulation for art dealers, the money laundering laws apply to art dealers.
Thank you very much for talking about the landscape of the US regulations for the time being. Andrew Adams is one of the center's advisors, and before joining STEPTO, he led a very interesting organization entity called Klepto Capture Task Force, which is how he got on the radar of the center. Andrew is going to talk about the enforcement of the anti-money laundering regulations and the sanctions regime that are happening now.
Right, so I'm going to put my Department of Justice hat on. So this is all through the lens of criminal law, not the regulatory or specifically the sanctions regime that the US also has in place. And it feels a little counterintuitive to say it, but I do think, drawing off of something Sam said, there is a national security concern that I think is sort of at the marrow of the way DOJ thinks about the art market. The very first sort of organized prosecutorial effort in the United States that focused on the art market comes out of World War II. It's Roberts Commission, the Monuments Men, and it brought together prosecutors, it brought together former judges, it brought together intelligence agencies and military to investigate looted art for a diplomatic purpose and for a national security sort of purpose. And for decades, that was really sort of the bread and butter of what DOJ did in the art market. It went after looted artwork. In the early 2000s, DOJ set up through the FBI something that still exists today called the Art Crime Team. It's a national team. It has a handful of agents situated across the country that specifically focus on the art market. And its motivation was, again, expressly a national security concern. It came out of a worry that during the war in Iraq, that there would be, again, looting of sensitive material, and it's sensitive in a diplomatic and national security sort of sense. That's what motivates DOJ at heart. And I think that's still the case today. And you see it in the kinds of cases that DOJ tends to bring in this space. It's looting and looted artwork. Even today, DOJ and the Southern District of New York in particular has a fairly steady pace of Nazi looted artwork cases. That is the legacy of that original sort of national security concern. More to the specific point of today's conversation, the money laundering space. Sam's laid the table on sanctions. And sanctions are a national security tool, or they're thought of as such. And to the extent that DOJ is not running after stolen artworks and looted artworks, it is largely looking at the possibility of sanctions evasion in the art market. Zach mentioned this also, but there have been a handful of cases recently that touch on terror financing through the sale of artwork. There was a Brooklyn case In 2023, Nizam Ahmad was the defendant. That case is still ongoing, but it was predicated on sanctions violations tied to Hezbollah and the sale of artwork for the purpose of promoting and funding that sanctioned organization. The energy and DOJ, at least up until a few months ago, in this space was definitely focused on sanctions and sanctions evasion. Not specifically in the art market, but it touches on this market because many of the cases that DOJ was pursuing were in, call it generally the luxury goods and oligarch space. And so as a part of that, you saw the seizures and forfeiture of luxury items, some of those squarely in the artwork world, some of those sort of adjacent to it, yachts and airplanes and things like that. And that's where I expect DOJ's interest will continue. Notwithstanding shifts in administration and shifts in priorities, national security continues to be at the top of the list of enforcement priorities for DOJ. That may move from Russia to cartels in South and Central America. That may switch over to a focus on sanctions parties in China at some point. But when the art market gets touched, it tends to get touched through that vein and through that national security lens. And happy to talk about what the tools are and what those cases look like on a practical matter, but I'll stop the filibuster now.
Thank you. So what does it mean in practical terms for art market participants?
Well, I think there's going to be good answers around the table on this one. From a DOJ perspective, art market participants are like everybody else in the country. They're subject to the general criminal laws. And so regardless of Treasury or Congress's ability to draft a statute or draft a regulation that speaks specifically to the market, that's not literally, it's not a get out of jail free card in the DOJ sense. And so know your customer policies and due diligence and enhanced due diligence when you're dealing with people or institutions that are in particularly sensitive parts of the world are the best practices, and conversations about those kinds of policies and procedures exist even in institutions that are technically unregulated institutions. Large auction houses, large galleries have these kinds of policies, and they look very much like what banks do or try to do, notwithstanding the fact that they're not affirmatively obligated to do it, at least outside of the antiquities sense. But I think Zach and Sam probably have some additional thoughts on that one.
Yeah. Hold on. We have to announce one of the CLE codes. I'm sorry. So
That's very important.
very important. We did not announce it twice. So the first code for the CLE credit, for those of you joining us online, is Money 25. Very catchy. So again, the first code for the CLE credit is Money 25. Okay. All right. So is it fair to say that one of the takeaways, again, we've been hearing from lots of different experts, and everybody has an agenda. I clearly have an agenda. My agenda is for people not to engage in money laundering. Is it fair to say that we don't need additional new regulations because we have sufficient regulations to prevent money laundering in the first place? You don't need to have, Irina Tar says you cannot money launder regulation for me to not money, is that one of the takeaways?
Well, let me, again, sort of putting the DOJ hat on. What has DOJ said about this in the last several years? They've made not art market specific recommendations, but they've made recommendations to Congress about the expansion of money laundering laws and the consequences of the violation of criminal money laundering laws in a number of contexts. The expansion of the forfeiture powers and what you can do with objects or property that the government identifies as violative of certain sorts of sanctions. So the department has definitely asked for additional powers at different points. It is almost certain that the current department would not endorse or re-endorse the same things that were requested in the Biden administration. And most of those recommendations are not things that Congress took up even during the Biden administration in a relatively friendly congressional environment. So regardless of what DOJ wants, I think they're probably stuck with the laws they've got for the moment. And those tools are remarkably powerful when there is the political will to go and enforce them, and when there is international cooperation on driving those things forward. Many of these cases rely on piercing through fairly opaque and cross-border financial networks.
Just one point to add, I mean, so Andrew made this point, but I think it's worth sort of expanding upon. Money laundering is a crime that applies to all US persons, right? Every single individual sitting around this table, every art gallery, every museum, every bodega on the corner, right? All of them are prohibited from engaging in money laundering. Sanctions also apply to all US persons, which means all citizens and permanent resident aliens, everybody physically located in the United States, no matter where you're from. Businesses established in the United States, foreign branches of those businesses, and under certain circumstances, foreign subsidiaries of those US businesses. So it is required, every art gallery in New York City must comply with OFAC sanctions today, no matter what. It's only the specific anti-money laundering laws, the BSA, the Bank Secrecy Act, and its implementing regulations that apply to this narrower category of persons, natural and legal, not natural persons in some circumstances, but principally legal persons that are financial institutions. And again, even the term financial institution is pretty broadly defined. See our friends in the boat dealing and telegraph agency business. So I think there is already, and then Andrew didn't touch on this, but there's also sort of beyond money laundering, there's lots of other criminal statutes that could be potentially relevant in illicit transactions in the art space. Bank fraud statutes, statutes that prohibit lying to government agencies, right? So there's a pretty, I would say, thick body of law that governs illicit financial activity in the art space, but in all spaces at the moment. The question really is, and the things that you would do to, as an innocent gallery owner, to defend yourself in an inquiry, if there were such an inquiry over violations of the money laundering laws or the sanctions laws, are kind of the same types of things that you would want to know or would be mandated to do if the galleries were subject to the anti-money laundering laws, as they are, by the way, today in the UK.
And those inquiries happen regularly. Auction houses, galleries get process from the Department of Justice and maybe from Treasury directly with hard questions about where did some piece of art come from? Where did this payment come from? And so the kinds of prophylactics that you see the banks using are certainly advisable in this space too. Get the records, know your customer.
The third category of we're asking questions, we're also laying a bit of foundation. So Zach, if you don't mind speaking, I'm afraid what you're going to say, but can you talk from your point of view the impact of AML regulations as they are on the private sector, how the art dealers are coping, are they struggling, or they're fine?
Well, so at the moment in the US, there are no AML obligations that apply to art dealers. I will say, in some senses, the banks are sort of quasi-AML regulators in an interesting way. So we work with galleries who routinely get questions from their banks about what sort of sanctions and AML related due diligence can they do, either as a general matter or with respect to very specific, often large dollar value transactions. So I'll say what I see galleries doing today, and I think it falls, and maybe just elaborate on points that Andrew already made. falls kind of into 2 or 3 categories. One is knowing your customer, and I'll talk about what that means in this context. 2 are sort of contractual protections that galleries put in place. And the third I would call just like awareness training, those kinds of things. So in the first, the real risk derives from anonymous and or cross-border and or high-value transactions, right? Like that's really where the money laundering and sanctions related risk derives. And in the art world in particular, there's a particular risk derived from the role of art advisors, right? Which is quite common. And what that means from a sort of money laundering perspective is you have an advisor come in, they're not buying the work themselves or selling the work themselves, right? They're standing behind some principle. And as a historical matter, I think it was considered a little bit like uncool sometimes to push the advisors on whom they were representing on either end of the deal. I think the norms around that have changed significantly in the last, call it, decade or so. And I think it's now totally expected that if you're engaged in a deal and you as a gallery or you as a dealer yourself are facing someone who is obviously not the principal in that transaction, to not proceed with that transaction unless and until you know the principal behind the transaction. And that could either be, it could be because they're being intermediated by an advisor or a dealer. It could be because the actual person, the actual legal entity counterparty in the transaction is a legal entity, right? And you need to understand like who's the beneficial owner of that legal entity. That may not be true at all dollar values in the art world. Like you may see smaller transactions where our advisors aren't pushed to identify the principle they're representing. But I think when you hit a certain, and I was gonna say it's more art than science, but that's like pun semi-intended in this context. Like I don't think there's a hard threshold, say like above 50,000 or 100,000. Certainly when you start to get into like relatively large numbers, I think most responsible galleries will not transact unless they understand who the actual parties with an interest in those transactions are. And they do basic sanctions related due diligence. They do Google searches, like, are there newspaper articles about this person being indicted for money laundering? OFAC's SDN list is public. It's on the website. Anyone can search it. People search the SDN list, things like that. So that's sort of like thing one is like, don't do high dollar value transactions where you don't know the participants in the transaction. The second is contract terms. So as I alluded to, it is now totally common. Nobody would transact any work with any real dollar value without representations as to authenticity, right? And I think it is becoming more common to see in, standard form consignment agreements and standard form loan agreements and standard form purchase and sale agreements that galleries have, that there are representations and warranties about sanctions. And they basically say, you as buyer or seller or consignor or purchaser or whatever are representing to me, the gallerist, or me, the dealer, that nobody subject to sanctions has any interest in this transaction. They're not buying the work, they're not selling the work, they're not lending against the work, they're not whatever, right? So that's a second thing, I think, at least I see regularly.
On the contract point, I should emphasize that just the contract in itself and no substance to like actually doing the diligence becomes a red flag when DOJ starts asking questions.
Yeah.
Those go hand in hand.
Yeah. Right. Also, don't ever have policies that you don't actually implement. And then the third, I think, is training and awareness. I think at least in the larger galleries, and I've done like sanctions training for larger galleries, they will, in the past, maybe it was only like the accountant or the bookkeeper who had kind of like some awareness of these issues because they're often dealing with the banks. And so they're often getting questions from banks about transactions. But I do think that there is some awareness, more than some awareness at this point, among like, again, larger galleries that are routinely transacting in relatively large dollar values, that are routinely transacting across borders, that this is like a thing you need to pay attention to, and that you need to make sure that the people who are responsible within a gallery for contracting and onboarding new clients and the like kind of have at least more than a vague understanding of what these issues are about, and more than a vague understanding about what they need to do to mitigate risk in this space.
Not to oversimplify some of this, but part of this is like common sense.
Yeah.
Like, you'll see a lot of AML indictments that involve, well, not as much in the art space, but in other spaces where you had people who were not exercising common sense. So if someone walks into a gallery and says, I have a bag of, $400,000 in cash, what kind of art can I buy? I don't particularly care what it is. I just need something, and particularly something that's small enough that I can carry it with me on a plane. There's no law that says, you have to reject that. But like some common sense there is to say, wow, this is pretty unusual, and you want to have, you would want to take appropriate steps, before engaging in that kind of transaction. And if you think, from a perspective of like what money launderers need to do, and you think about, the cartels, which is a big focus for the current administration, they have lots of illicit cash that they generate in the United States, and they need to find a way to get it out of the United States. Small pieces of valuable art, that's like something that might be of interest to an international money laundering organization like a cartel. So exercising some, fairly basic, you don't have to be a sanctions professional or AML professional to be working in this space and to be able to exercise appropriate due diligence. There's a whole professionalized world then also, like when you're onboarding a client, there's all sorts of screening that's done against a name for a sanctions check and negative news searches and so on, and trying to be able to identify the beneficial owners of companies. But a lot of this is just, having, Andrew, when he was at DOJ, if you saw sort of certain fact patterns, that's where you start to veer from, just, a gallery that may have made a mistake to, also potentially being complicit in criminal activities. You start to veer into territory of, actively helping a criminal organization conduct money laundering.
I'll give you a real life example from about 2 weeks ago. One that I think Andrew probably would have salivated over. Client calls and says, here's the fact pattern. You have high value work and a potential buyer. The buyer is an LLC. The person that we're getting a call from is a lawyer advising the LLC. The lawyer is also the person that established the LLC. And when pushed for the beneficial ownership of the LLC, and the money to buy the work would have come from the lawyer's client account, right? Which is to say, like the trust account that the lawyer establishes to hold client funds. And meaning it would look to the bank, to my bank as the seller, as the gallery, like a wire was just coming in from a law firm. And when pushed, the lawyer refused to reveal the beneficial owner of the LLC and instead said, some other law firm will perform diligence and they will confirm for you that this is okay. And the question I got from the client was, this is like one of the fastest phone calls I've ever had, we'd be crazy to do this deal, right? And the answer was, yeah, you'd be crazy to do this. I mean, right? So like, think about all of the steps that person took to obscure the actual source of funds for that purchase. And I think that's the kind of thing where I would be really surprised if any reputable, sort of reasonably sized gallery were willing to engage in that transaction in 2025. I think the answer might have been different 7, 8, 10, 12 years ago. But I think today, I mean, I'm curious if anyone has a different view, but my sense is among the auction houses and the sort of larger galleries that routinely operate across borders, nobody would do a deal under those circumstances.
Second code is AML 25. I think Zach said it'd be crazy and 25 to do something like, so the second code is AML 25. I have a question for you, or for all three of you. So that was a quick call with the client. Is there, there's no duty to whistleblow, but this client of yours, could they not indicate which lawyer was giving them a call?
You want to talk about the whistleblower?
Yeah, I mean, so there's a whole complicated world of whistleblowing, and which is really just if you have information. I would sort of separate it into there's a world of a voluntary self-disclosure, which is when, Andrew is probably the best person to talk about this, is you have potentially done something wrong and you realize that, you know, there may have been either a mistake, or you identify that someone deliberately did something within an institution, and there may be criminal liability. There are benefits that are conferred to the organization for filing a voluntary self-disclosure with either OFAC or the Department of Justice. So if, you know, you're in a large gallery or auction house and you identify that, you know, we realized that this person we sold this painting to 2 years ago, it turns out, you know, we now know this is a sanctioned Russian oligarch, you might consider taking appropriate steps to file voluntary self-disclosure, which is a fairly routine thing that financial institutions do all the time. There's also separate set of regulatory frameworks around whistleblowing, including around sanctions and money laundering, which is partially a Treasury and partially a DOJ thing. And there are incentives that are offered to persons who can provide information on violations of the sanctions and AML laws. And so that's something, you know, that we see, you know, like sort of like insiders at financial institutions or insiders at different companies will come forward to DOJ and say, you know, I work at company X and I know that company X is violating sanctions or AML or company Y that we're a counterparty with. So it's something that was a big priority for the prior administration, and then actually the new administration is sort of will continue that, but may shift some of the priorities there. But it's a risk for large institutions to think about, which is that, you know, it's possible that you know, you could end up in a situation where, you know, an employee takes information to the government. And so it's just another way that the government is carrying on these types of investigations.
Right, but we're talking about smaller size businesses. For
Yeah.
example, a gallerist who was approached about something like this. I know there is reputation to be maintained, that it might not always be good for the reputation, but is it not good for the art market? Because if this lawyer created this LLC and has the money from some account, they will probably go to another dealer.
Maybe.
They will go to another dealer.
Right. Look, I mean, do we know that that person was engaged in illegal activity? No, of course not. No idea. The question is one of risk. And I would think that the threshold, there are the threshold to decline to participate in a transaction is different from the question of like, should I go run and tell the FBI about this? Right. To me, I would want, you know, to wrap somebody up in a criminal investigation, huge deal. And personally, I probably wouldn't do that unless I had some like actual reason to believe they are actually engaged in criminal activity. You know,
And if they are, for example, your client knows that they are.
if I knew, if a client came to me and said, I know this dealer, this advisor is acting on behalf of a sanctioned person and trying to, you know, trying to circumvent sanctions by buying or selling a work of art. And I knew that to be the case, like I had actual knowledge of that was the case. Would I advise them to go forward to the FBI? Potentially, yeah.
I think of clients that are on the receiving end of that pattern where you know that you are being exploited tend to view themselves and understand themselves as victims, or attempted victims of a crime, and are often willing or eager to go.
And I think that law enforcement tends to view them as victims of crime, and so it does not.
But a lot of this space, I think of as sort of these risk-based decisions. Zach's called his client, or you have someone who walks in and tries to purchase something where it just doesn't feel right. You know, a lot of that is the sort of risk-based decisions that financial institutions make all the time to close a customer account because you say, this is a business that we think should be making $100,000 a year, but they're, depositing $1 million in cash. They're not saying, we know for certain that this is a money laundering operation, but you're making a risk-based decision to protect the reputation of your organization and take appropriate steps to prevent money laundering.
Do we have questions from the attendees about what we've been discussing? Do you have questions for each other? I mean, I know that you guys have you ever sat across from each other in a matter? How would that look like?
It would look cordial and collegial.
Andrew was at the Justice Department, I was at the Treasury Department, which could get quite antagonistic. No, I have one question I posed to the group, and I think it's very interesting. The government and the new DOJ priorities have been very clear that cartels are really like the top priority, and basically anything within the cartel. So I think a lot of the focus in the space over the past couple of years has been in the Russian oligarch space, and I think it'll be interesting to see as prosecutors start looking into the financial operations more of the cartels, which has also been picked over pretty well, I think, over the past number of years. I don't know if there'll be any new typologies that we see that come out.
I have actually two questions. First, like more from the practical side about the diligence during the art fairs, because I don't know how it works like in the US, but mostly in Europe, for example, New Art is one of the biggest art fairs. There are 100 like art galleries there. There are a lot of people who are going and passing by and they want to buy art. It's not so expensive, but it's like 10K, 15K. So what the art manager, like the art dealer needs to do like during this time when like the buyer came and he's ready to buy like art piece like now, for example, by cash, or just like, I don't know actually, do they have cards, but I think mostly it's invoices. So, okay, like they can go fastly and look for sanction list and see, but it could be like a manager, the assistant of the person who's in sanction list, and he can pay back his like banking account. So what will be a good phase for them to understand like fastly first, because like in art first, they buy art like the same day. To act and not be in the problem that like they sold art to the sanction person.
So again, risk-based analysis on all of this stuff. I mean, from a sanctions perspective, art fairs it's certainly, again, from the DOJ perspective, didn't strike me as the place where Russian oligarchs go to move their money. Understanding sort of the motivating factor behind large scale sanctioned individuals, it's largely, I want to park an enormous amount of money someplace that will be safe and secure and not so retail transaction. I'd be more concerned about Sam's point about, here's a big bag of $20 bills to buy a $10,000 artwork. Like what's going on with that transaction? That seems odd. But practical matter, at the art fairs, at least that I've walked to in New York, tends to not be cash based. You got to have a conversation with the person. We're talking about credit cards, we're taking IDs, kind of basic blocking and tackling on the notion that somebody's there to like wash their fentanyl money.
I'd always be more concerned about cash for sort of the obvious reason that you can never rely on the due diligence that a bank did, a legal matter, but if someone comes to you and says, here's my account, I can write you a check from my account at a major bank, you have some degree of confidence that a bank did some diligence on them, whereas a bunch of cash is, the definition of sort of, that potential money laundering risk of having to introduce cash into the system.
Can they, for example, have some like blank that they have about the name and surname of the buyer, and then they will have like confirm that you're not acting on behalf of the sanction person, like, and they will click and they will sign it. So it will be like additional like due diligence that you ask the person to agree that they are not.
Yeah, and to Zach's point, like you can have policies, you can have contracts that do that. If that's the only thing you're doing, then it's unlikely to be convincing to if somebody's asking questions after the fact that you put that in front of somebody. In fact, what it suggests is that you had some suspicion and that did nothing to check on this.
And another thought to keep in mind is that the penalties for money laundering are very severe. There's potential of going to prison. There are hundreds of thousands of dollars in fines. So as much as somebody wants to sell a work of art and get something done, I think if there's a pressure of time saying, let's do this now, here's money, I'll take the painting. I think for a dealer to stay in business a bit longer than 5 minutes, they should slow it down as much as possible. There's absolutely no need to rush this. If somebody says, I am getting on the airplane in 3 hours and I have this money and I'm on the spot, you go, terrific.
Yeah.
Have a nice flight.
And to Sam's point, it is a kind of, in the space where where there isn't a BSA obligation to go above and beyond, where you have this affirmative obligation to conduct specific levels of due diligence. You are like anyone else in the world, and there is not there's not some heightened expectation that merchants of all sorts are going to be conducting deep dive due diligence in normal sorts of transactions, and people who are in the art market are merchants of normal sorts of transactions. There are situations where red flags are obvious and alarm bells should be going off, but I don't think DOJ or Treasury or most people think that any standard transaction, including at art fairs, is sufficiently shady to warrant that in every single case. But if it's a plastic bag of $20 bills, then that's the question.
One of the projects of the center, I'm here not only to moderate, but to plug the Center for Art Law as much as possible. So one of the projects that we have been working on slowly is doing a study, collecting information about how different countries are dealing with anti-money laundering regulations in connection with art market transactions. So it took us a few years to get the first study out, and we're in the process of updating this comparative study. We'll have new jurisdictions like Switzerland, for example, and India and others included, with the idea that in every jurisdiction, wherever the dealers are participating, they need to know the regulations and they need to comply with those regulations. Some regulations are more firm and stringent and some aren't, but we're hoping to assist with a way for dealers and lawyers to find information. If it's difficult to find, hopefully it's a first step. So my question to our speakers is, I know you're experts and barred in the United States, you're American lawyers. Other jurisdictions with which you work and you think we United States do it better. So you feel United States is better prepared than, let's say, I don't know, Paris, France, or you think, oh, they are doing it much better and we should follow in their steps.
Happy to react from an enforcement standpoint. There is no comparison anywhere in the world with the United States' law enforcement abilities and the devotion of money that goes into that space. There is I think a great deal of interest in pursuing enforcement in the UK and in the EU, but they just don't fund law enforcement remotely to the level that the United States does. Whether it's better or worse is sort of a different order question, but in terms of effectiveness of the enforcement regime, the US, I think, stands head and shoulders above.
Yeah, I'll just add, to Zach's point earlier about thinking about the totality of the money laundering landscape. The art market is always going to be smaller than the type of money laundering that can be done through hedge funds, which is of great interest to the Treasury Department. But I will say it's sexier, it's more interesting, and that the stories are just something that people are interested in a way that money laundering through a hedge fund, which we can also talk about, is not nearly as interesting. And that also means that it is always going to be of more interest to prosecutors and to the press. And so I think the amount of attention this is going to continue to get will continue to be significant, even absent some of the same regulatory requirements.
Yeah, it's more interesting than long-dated credit default swaps.
Say that again, long daily life. All right, so, okay, if that is true, might be true. What about digital art? Is that an issue that is any different? Because you don't have to actually pack it up. It's, once we receive the donation of a sculpture, we'll never, ever accept a sculpture as a gift again. It's just impossible to schlep around. But a file is even easier to transport than painting. And anything about digital realm that you think we should know about?
Well, if we're talking about NFTs as digital art, then the overlap between art and financial instrument is total. So it presents the opportunity to move money in kind of the same way that Bitcoin or other cryptocurrencies present the opportunity to relatively quickly, relatively pseudonymously, not entirely anonymously, move funds from one person to the other. And it's a very good way of moving funds across borders without reporting. So it presents that that opportunity. My sense, at least on the sanction side, is there are technological and financial realities to doing that at scale that make it not such an attractive route for moving money, for hiding money. It's relatively expensive to conduct large-scale blockchain transactions as compared to offshore transactions or real estate transactions. It's actually slower than people think as compared to the banking. And then it's tough to get it back into a form where you can go and buy, a missile if you're Hezbollah. So the possibility, I think, lurks out there. We haven't seen huge enforcement cases that follow that typology, and I'm not totally surprised yet.
Zach, do you have anything to add about digital art, or it's just like hedge funds?
He probably has more in common from a financial crime risk perspective with a digital asset than a work of art, for the reasons Andrew identified. Right? It is more like an Bitcoin than a basket.
We have a question posed online about, I suppose it's a red flag whether artworks sold in a money laundering transaction. Do we see inflated values or below fair market values instances there? Or that's not an indicator if something sells way above what the fair market value would be or way below?
It certainly can be. Deflated values, and in particular, start to seem like somebody's just trying to offload an asset very quickly. Whether that's because they're laundering it or because you're dealing with stolen property is sort of a similar question. But that's certainly a red flag.
I have a question. What is like the international regulation if a person money laundered not only in the US? What is the procedure? Do you collaborate with a firm outside of the US, or do you open two processes, one in the States, one abroad? Like, how does it work?
Sorry, from a law enforcement perspective? It's a great question. So you can often DOJ works in tandem with foreign partners and will do parallel investigations. Many cross-border investigations, certainly in the sanctions space, require that there be some kind of cross-border communication and exchange of information. In the offshore financial market, when you're talking about, to Zach's hypothetical, the offshore LLC that's set up in BVI, you can't get information about what's going on there unless the BVI authorities are working with you, or well, there's some other ways to get that, but generally you need the BVI to help you out. And then how those result or often shake out will be parallel actions. And you've seen that in some of the art and art adjacent kind of situations. There were, in the sanctions case in particular, DOJ brought a handful of cases at the same time that the UK would bring cases, or the UK would execute on seizures. So for the most complex cases, I would say it's almost standard operating procedure at this point for people operating cross-border.
Thank you.
Yeah, so I have a question again about sort of these practical ways that our market participants would do their KYC, because I've heard mentioned here like Google searches, I've heard this OFAC list. I mean, I've just seen the OFAC list, which is like 3,000 pages of like very small font and just a whole bunch of names. So it doesn't seem like it's a very easy way for people to do it. So like beyond, let's say, putting the name into that PDF of 3,000 pages or Google searching, is there any, I mean, what else would?
Good news, there's a spreadsheet version too. It's like,
There should be like a search function.
yeah.
There's a lot of like subscription-based services, like LexisNexis has something. There's something called World Check, which are just sort of like bread and butter due diligence tools. So you put a name in there and they aggregate a lot of these different databases. So not just stuff like the OFAC list, but also other sort of, you know, lists of things, and they'll just sort of spit back a report. So, you know, there's a variety. I don't know sort of what the main one is that might be used in the art world, but those are sort of just general good things to have.
One more question about the artists. So what should you tell artists, like if they speak with lawyers, to do if they buy through, for example, Instagram, because now there are a lot of artists who sell their works and there are a lot of buyers who just write them like through Instagram that they want to buy your work on your website or something. And I know a lot of like some artists, and like for sure they like what will be for them like a basic minimum to do, like to follow if they don't want to do, for example, but still want to do like to sell art by themselves without art gallery.
I think in the interesting thoughts, you know, in the AML world, we talk about sort of a risk-based approach. And I think the expectations on an individual selling art they're making are going to be very different than like a major gallery or a major auction house. I think again, it's a lot of the sort of common sense. Like I bought art off Instagram once and like had it shipped to my apartment in New York. You know, if someone's saying, you know, I need this shipped to Moscow or something, right? Like that might be different. But I think that, you know, there's probably not a need for them to set up like a compliance infrastructure, but they should use, you know, what sort of approaching these issues.
In the UK's rules that just went into effect actually carve out artists who are selling from the specific additional due diligence requirements. But to Sam's point, the background law against fraud and money laundering still apply.
So do you work with dealers who are not American citizens, American entities? Do you give them different advice because they are residents in a different jurisdiction?
Well, I mean, there's a specific set of regulations that apply to art dealers in the UK and the EU. And I understand those rules. I'm obviously not a UK or EU qualified lawyer. So, you know, if you're an art dealer in the UK or in the EU, you have again, like a specific body of rules that applies to you. But I think the basic common sense due diligence, a dealer from Singapore came tomorrow and asked me, like, what do I do in this space? I think the answer would be basically the same. You know, there's a set of common sense due diligence. I mean, I think one thing to think about that all of these like effectively amounts to is, do the economics of this transaction make sense? Right. And the economics are both the price, the mechanism of transaction, like why would somebody show up with $40,000 in a bag of cash? Like that just makes no sense. Nobody does that anymore. And I think asking the basic questions about with whom am I dealing? Do the economics of this transaction make sense? You know, does it all add up? Does the person tell me they're from one jurisdiction, but then they ask me to wire funds to a different jurisdiction, and then they have an LLC incorporated in a third jurisdiction? Like that just kind of doesn't really make a ton of sense. So they just, folks keeping their antenna tuned to these questions about like the economic rationality of a transaction, I think is fundamentally the way to keep yourself on the right side of risk.
I have a rather specific question. What happens, again, I think when you mentioned if an entity is owned half or more than half by a person on the list, that needs to be revealed, etc. What happens if somebody is not yet on the list, is a majority holder, and then transfers the majority stake right before getting onto the list.
Yeah.
Is that good for them? They got in before the curtain fell, or it's also an indicator of some kind of illicit activity which can undo the transfer?
Yeah. So this happens not in the Russia context, where like miraculously, a month before the oligarch was sanctioned, he restructured his trust, and so he's no longer blah blah blah, or he, divested his ownership interest in the LLC to his children or whatever.
His soon-to-be ex-wife.
Or his soon-to-be ex-wife, right? Tough times. We deal with these. I see these facts. I actually don't see this in the art world, but we see this in the banking context all the time, where a bank has a client and there's some complex restructuring, and the question is, usually immediately before or immediately after the bad guy is sanctioned, and the question is like, can we keep doing business with this person? Do we have to self-report? I mean, and I think the legal question under US law is, does the sanctioned person have a property interest in the legal entity? And does that property interest exceed a percent ownership threshold? And property interest is defined expansively. And so I personally tend to be very skeptical of those kinds of miraculous reorganizations. And there's guidance from OPSI and from OFAC that kind of indicate the same thing. Like, you should treat with OPSI as the UK equivalent of OFAC, Office of Financial Sanctions Implementation. So I am personally, and I think most clients with whom I deal are very skeptical of those kinds of miraculous reorganizations. What you do in any specific circumstance is a very sort of fact-sensitive question. Do you have to self-report? Do you not have to mean, those are kind of complex questions, but the general principle that like some Russian oligarch managed to totally restructure his ownership holdings, 2 weeks before he got designated, look at that lucky guy. I tend to be very skeptical.
Yeah, although as a legal matter, if the question is what do you need to report with respect to block property, if the person's not sanctioned yet, then their property is not blocked. You don't have something that you have to report in that situation.
I have a question for Zach. In your example about the LLC who you didn't know the owner of, what impact does a FinCEN's obligation to, are you supposed to be filing those beneficial owner reports to the government, so the government at least would know about it?
Yeah. So that was, well, you could ask people on Capitol Hill about this, they're very sensitive. So there is a law on the books that says, broadly, US legal entities have to report their beneficial ownership to this database created by FinCEN. And that took years and years to implement, very complex rulemaking, blah, blah, blah. And then the Trump administration dramatically narrowed the scope of that obligation 2 months or so ago, a couple months, 2 or 3 months. There are something like 15 million US LLCs that have already reported their beneficial, and the way they narrowed it basically is to say only foreign incorporated legal entities that have registered to do business in the US have to comply with this beneficial ownership reporting law now. So a US legal entity owned by a US person that is established tomorrow does not have to report its beneficial ownership. And there's a question about what the government is going to do with the 15 million corporate records that it had already collected before the Trump administration narrowed the obligation. So I think there was a sense that when it appeared to be the case that this is called the CTA, the Corporate Transparency Act, when it appeared to be the case that the CTA was going to come into effect and there was going to be a registry of beneficial owners of US legal entities, that would have the effect of mitigating risk somewhat. I don't know that it would, in the hypothetical I described, I don't think it would have probably changed the way I would have thought about the situation. Because there's nothing, just like somebody who's like really a bad guy isn't gonna self-report the accurate information to the government, right? But now that the law has changed, I think, the law hasn't changed. Now that the obligation was narrowed by regulation, I think that isn't much of a factor in anyone's thought process anymore.
I have to step out. I have to get on a client call on much less interesting issues, but this has been all fun, but I don't mean to cut us off.
Thank you.
Thank you.
Is that all right? We have a few more questions. Is that okay?
Yeah, I've got, let me get Sam to the right place.
Okay, so I had a quick,
I was just wondering if you have any insight into how auction houses are managing the whole KYC with cryptocurrency as those kind of transactions are becoming more and more frequent and they're actually very high stakes. There are extra steps. I mean, it seems like a rather difficult thing to manage. Are they doing it upfront before the sale? Do you have any understanding of what that takes? Rather than, you know, a normal kind of wire transaction?
Yeah, I mean, so the answer is, as a factual matter, I don't know what they are actually doing to manage the risks around those kinds of transactions. I have thoughts about things that they could do to manage risks around those transactions, but I don't know what they're actually.
And what would those?
So, I mean, I think you could, for example, require, so what is fundamentally one of the aspects of digital assets that makes it higher risk is that you can conduct a peer-to-peer transaction without either of us being onboarded by a financial institution. So one of the things you could say is, okay, we will only accept digital asset payments that come from an account held, you know, nonetheless, notwithstanding the fact that you can engage in peer-to-peer transactions without intermediary financial institutions, there are nonetheless many crypto exchanges, is what they're called, and they're regulated sort of the way banks are regulated and broker dealers and other financial institutions. So the way I would do it if I were advising an auction house to say, look, you know, one way to dramatically reduce your risk is to say, I will only accept crypto payments that have come from an account at a US regulated financial institution. So you can have some degree of confidence that you know, you've sort of outsourced at some level the due diligence on that crypto wallet to that financial institution. I mean, that to me is the most obvious. And then I would have, you know, all kinds of representations and warranties. And the way that you guarantee not guarantee, but a due diligence measure you could take to try and confirm that the person is in fact using an account at a digital asset exchange is by using their sort of special software that has been developed to screen digital asset transactions, and those can identify like, yeah, okay, that's a transaction coming from this exchange or that exchange. So that's probably how I would think about it.
There's a question.
So I think that you briefly mentioned, that you're talking about the LLC setup and like how lawyers and accountants and stuff end up facilitating some of these transactions. And I know there was an attempt by the US, the Enablers Act to
Yes.
get those people covered. Is there a reason why like there's been less of an appetite for that? I mean, that seems to be like.
Yes. So that is for sure, the Enablers Act specifically remains, so the Enablers Act would extend certain anti-money laundering obligations to enablers, which is to say like certain gatekeepers in the financial system. So certain lawyers engaged in certain types of functions, not like the stuff Andrew and I do, but if you're a lawyer whose job it is to like establish companies and serve as a nominee director and sort of things like that, you would be subject to AML regulation. There are jurisdictions in the UK and I believe in the EU where lawyers serving in that function, serving as fiduciaries right, are subject to anti-money laundering regulation. Accountants in this sort of acting in similar capacities also are subject to AML regulation. So I know that that is a priority for certain folks in the staffs of the House Financial Services Committee and Senate Banking Committee and the like. And so I think it's really just a question of legislative opportunity and the alignment of interests in the committees. I can't personally see that legislation moving forward in this Congress. But you know, in 18 months, things are going to change, maybe. And so the priorities of the various constituents.
But it also doesn't, this kind of legislation, like CTA, for example, it doesn't necessarily have a perfect two-party system valence. The CTA passed over a veto and brought Republican and Democrats to the table to do it. So if there's a political appetite, for example, to go chase cartel financing, you probably see that as the vehicle through which it would happen right now.
Do you have any takeaways for us? I mean, except that, you know, wait and see, there are regulations already in existence that do a lot.
Yeah, I mean, the one is common sense, right? Like, just don't take the bag of cash. But the other is these conversations are always sort of jarring and can be really, you know, you sit here dwelling about the possibility that the cops are going to come knock down the door. And what I would actually leave people with is the notion that most people are acting in good faith and most people are actually trying to participate in the market in perfectly legal ways. And in this market in particular, there are many, many people of goodwill. And it is not really, I think, top of mind for DOJ for all the reasons that we've talked about previously. So when you're dealing in common sense and in good faith, you should feel confident about your ability to operate in this market, and lucky to be in it, I think.
Thank you very much. I'm gonna
Everyone.
close. For those of you online, thank you for joining us.
Thanks for making the trek, the 2 blocks over.
Well, actually, today we're way in Brooklyn.
Oh, is that right? Okay, all right. Yeah, you guys saw something.
All right, thanks for inviting me. Thanks, Amy. Really nice to see you. Thanks, everybody.
All of us. Zach, hold on 1 second.
Yeah.
Don't leave without.
Yeah. Yeah, the guy's name is, his last name is, I think it's, yeah, that's it. Ahmad, yeah, Ahmad, yeah, that's it. It's in the Eastern District of New York. Yeah, they seized a bunch of paintings. Yeah.
Going on, right?
It is because he is a huge, so he has never been arrested and it's just a criminal case that's sitting out there. At some point, there's a mechanism called civil forfeiture. They will probably file what looks like a civil lawsuit against the tenant or against the thing to move it, to give some finality. So that hasn't happened.
I'm ready.
Is the artist still the owner of the I mean, the
Yeah. And not all the.